Hi there. Welcome to Protect, Prevent, Profit. How legal support fuels agency growth. That was feeling like a mouthful for me. It's a mouthful. And I think because it's a lot of really important stuff that we want to get covered today. So I am Melissa Morris. I am the founder and lead strategist at Agency Authority. We help multi-six-figure agencies scale, again, break through those bottlenecks. We're going to do that leveraging our top framework, operations team, process, and pipeline. I have with me Sharon. Sharon, do you want to take a minute to introduce yourself, your business, and tell us what you do?
Yeah, Melissa, thanks for having me today. I'm Sharon Torek. I am the CEO and founder of Torek Law, which does business in the agency world as legal and creative. And we are a law firm that serves agencies, independent agencies across the U.S. We help them protect their assets and turn them into revenue in three areas, really: intellectual property, contract development and negotiation, and marketing regulation compliance.
Very good. So at Agency Authority, we help agency owners streamline, get a lot of their onboarding in place. That's often one of the first things we're looking at is client onboarding, delivery, and then even parts of offboarding. So as you can imagine, thinking of onboarding, things like contracts and proposals are always a piece of that and something that we encourage all of our agency owners to have in place and to look at. But knowing we are not legal experts ourselves, I wanted to have someone come in who does have that expertise and share what they know, give our agency owners things to look out for and be mindful of. One of the things that I often see when it comes to agency owners and contracts and other legal things, particularly the ones that we work with, where they're often overwhelmed. They're feeling the pull, right? They're ready to get going. They'll sign a client. They say, oh, they confirmed via email. We'll get the contract signed later. Let's get moving. Let's get going. And they're just ready to get the work done and get moving. And sometimes that legal point feels like, this is some red tape. I can kind of push it to the side or kind of worry about it later. And I know you have really great insight about how the legal stuff isn't just something that's going to protect us or we can worry about later, but actually is very closely tied to agency growth and can really support it. So why don't you tell us a little bit more about that?
You know, I think, Melissa, and as you and I were chatting priorly, I shared with you that I think agencies underestimate the value of legal process as a profit building tool for their companies. I think most agencies appreciate it as a tool for protection, maybe risk limitation, but the key, I think, to keep in mind is that legal operations should be a profit center for your agency, and you should treat them that way. And frequently, I think what we see, and I think it's because of a couple different factors, but we do see this reluctance around sort of formalizing relationships and even taking a step back from that, formalizing and systematizing your process for legal relationships between the agency and clients, the agency and independent contractors, agencies, whoever it might be. And so I think if you have taken the time and energy to systematize this in your business, just like I'm sure, Melissa, you counsel agencies to systematize other parts of their business. First of all, it's saving them fees, legal fees in the long run. It is saving them time to client execution of the contracts. And it means that you're less likely to miss any of those details that are likely to cost you money later on in the relationship, like scope creep, or an intellectual property issue that wasn't addressed correctly, or an exclusivity clause that you agreed to without really understanding what the implications might be long term. So think of the legal component of your business as not only what provides you a foundation to avoid risk, but what helps you earn more and certainly keep more of the money that you work hard to earn.
Yeah, and I'm so glad you brought that up about scope creep. And as I was just saying, I see this tendency sometimes to where they get the verbal, the agency owner gets that verbal and they're ready to move and go, and they don't have contracts signed yet. They maybe don't have an invoice paid yet. And in my mind, anything you do before those two things have been accomplished, the contract is signed and the invoice is paid, is already scope creep because you haven't gotten into an official and legal agreement to begin this work.
And you've also increased your risk. You've also automatically increased your risk.
Exactly.
Yeah.
Yeah.
I wish I didn't have this t-shirt, but all the lawyers and my team have this t-shirt of a client, an agency client, because we serve agencies at the firm, will come to us and they're all excited about a new opportunity. And either they've already started work and can you look at this agreement because we've already, started sharing ideas and concepts, and or we're starting on Monday and today's Thursday. And I think that agencies, first of all, they move very quickly from opportunity to opportunity. That's in the nature, especially of a small agency. But agencies also tend to have this thing about not wanting to look difficult to do business with. And for many of them, they fight this perception that coming to the table with your prospective client or your existing client for a new piece of work that you're going to do together, buttoned up and with a contract to slide across the table with terms you've already pre-considered and that are your standard benchmarks, is going to make them somehow look too obstructive or difficult to do business with or inflexible. And it's not true. It is rarely the case that your client is going to feel that way about pushing their agreement across the table at you. And if you're the kind of agency who says, we work with large companies, we work with enterprises, we work with government agencies, and we have to sign their contract, they're just not going to even look at ours. Okay, but having your own pre-considered set of terms and your own benchmark agreement helps you identify and understand where you need to quickly push back or negotiate to a center point so that you're making a deal and setting the tone for a relationship that's fair to everybody involved.
Yeah, I think that's a really great point. And it is interesting that the perception there can be sometimes that it feels like an obstacle or making it difficult to work together. And I agree, in my experience, it is the complete opposite. And one of the things we do work with agency owners on is let's systematize this, like get some process in place so that it feels really easy for the client to say yes, to sign off, to get that deposit paid, and to get moving. And so I totally agree. I think when done well and thought out and considered, it actually makes that process really easier. And to tie that back in a little bit to the scope creep conversation, I think the clearer we are in our contract and our scope of works, the better off we are in the way we can start to really reduce scope creep and really get rid of it altogether. And I know some of the things that I see many agency owners struggle with are clients who miss their deadlines, who ask for last things last minute. I know you see this too, because they say, oh, we're starting Monday and we only have the contract Thursday, right?
Yep.
Lots of rush type of scenarios. So I know I always encourage my agency owners to have rush fees or policies in place, missed deadlines. What does that look like? How will that impact timelines for clients? Right? There's a agreement that we're going to get your website live by June 1st, but that is contingent upon you getting me copy and approvals and such by your timeline and deadlines. How do you see contracts playing a role in things like monitoring those timelines that always want to get missed? Those quick turnarounds, can you do this right away? How do you recommend people use their contracts or scopes of work to help prevent those?
Right. Well, I think the first thing is that your contract should not be bashful at all and should be very clear about having a set of client expectations built into it. And these are the behaviors that you expect of the client. And they include things like providing information that is needed in a timely manner, getting responses back to you that will enable deadlines not to be missed, providing legal approvals of things that require them. If it's a website build and you're going to be including copy that, for example, includes product claims, who's reviewing that on the client team to make sure those claims are accurate? If you're going to be using imagery or other intellectual property in the end creative product, who's clearing that stuff to make certain that you're permitted to use it? If you're going to be doing an influencer campaign, who's making certain that the agreements with the influencers are buttoned up? And sometimes it's the client, many times it's the agency, but if it's a client, their responsibilities should be as spelled out as the agency's responsibilities are. And that's some of that can be reflected in the actual master service agreement itself. Some of it, more properly belongs in the statement of work. We always say at the firm that you use your statement of work for your 3Ds, your deadlines, your deliverables, and your dollars. Everything else is sort of a term that overrides the entire relationship. And so sometimes things change in the scope of work, and you can have a mechanism for dealing with that, a change order or revising the scope of work. But things like client approvals and behaviors, you mentioned rush fees. That's one mechanism for sort of incentivizing clients to not force the agency to rush its work schedule. Restart fees for clients who have allowed projects to go dormant, and which costs the agency money either because you've held headcount to serve that client and they got nothing to do because the client's not advancing the project. So, accounting for that based on the kind of services your agency provides. This can be more of an issue, for a digital firm, for example, than possibly for a creative or media firm. Every agency discipline has its own unique sort of deliverables and tasks that have to be accounted for in a scope of work document. And sometimes that can mean you need additional terms in the master services agreement itself. But the bottom line is the client's behavior should be committed to in the agreement, just like the agency's behavior is. And you're less likely to see that if the client is the one providing the agreement to you. So you've got to know to ask for it. And that's that back and forth process of redlining and pushing back. And it can take time. But if you've got your preset list of expectations, because you've taken the time to have your own agreement, and you know what your benchmarks are or your standards are, it's easier to get through that and faster.
Yeah, and we see that in a lot of different ways. That's what I always tell them about processes in general. When we know the target, what we expect and what we want, it's really easy to expect that from our team or our clients. And I love you said that don't be bashful. Don't be bashful about the client's expectations and have that clearly laid out. I think that is a massive takeaway for anybody listening. And the second thing is, I love you even pointed out ways that we can see legal helps your profit center, right? Okay, the scope creep that you talked about, the rush where we are pulling in people last minute, having them stay late. Maybe we're having to give somebody overtime for something, and then we're not getting compensated for that because there is no rush fee attached in our document. So I think you gave some really great examples too, just tying that back to how this does improve profit margins.
Yeah, and there are a couple of other things to consider too, just in terms of how they affect the fortunes of the agency in general. Exclusivity expectations by the client. If you are an agency that is willing to enter into or entertain the idea of exclusivity, sometimes agencies call this non-compete. It's not. It's an exclusivity clause. You should be pricing accordingly for giving the client the privilege of having you out of themselves, because you're foregoing another revenue opportunity. You should also be working to narrow that exclusivity as much as possible, so that you're leaving as much opportunity for other new business on the table as you possibly can. Those are things that affect the finances and how you can use legal as a way to increase the finances and fortunes of the business. The other thing is use of your intellectual property. Many agencies have their own proprietary IP that really is not going to be turned over as a work for hire, is repurposed multiple times for multiple clients, and making sure your agreement calls that out properly so that you're not limiting your ability to use it on a repeat basis is another way that you sort of nurse your profitability by using correct contract language. And some agencies even build separate profit centers out of some of their intellectual property. And so there are ways to address that in the client agreement as well.
Yeah, I think too, it's not directly intellectual property, but speaking to a little bit as we spoke about, you're opening yourself up for risk when you're starting work too soon before things are official. and maybe I've already got some great ideas for you. You're already sending those off, and then they don't move forward. And
Yep.
then you see months later, you're like, wait, that was our idea. And they've gone and executed it internally, or they've taken it to a different firm or agency to execute. So if they've got that contract signed and they're already working with you, I would imagine now there's more protection, or at least you've gotten paid for your idea, right?
Yeah. I think there are, again, this gets back to agencies and their reluctance to look difficult to do business with, especially in new business scenarios. And so we really drive across to our clients that if you're in a pitching scenario or an RFP response scenario, any new business development situation where you're sharing ideas, concepts, free form in an unprotected environment, um, those are free to use. Those are free to use, and there's really little to nothing you can do about being compensated for them. There are some things you can do in the new business process. The non-disclosure agreement is the gold standard. A lot of agencies won't use them because, again, they feel like it makes them look a little bit overly formal or difficult to do business with. That's not true in my experience, but that is the perception. So that's the gold standard. That way, even things that you share verbally, are covered, are protected. But there's some other things you can do as well in the new business environment. Protective language in your proposals. A lot of these proposals contain, pretty deep insights and strategic ideas. And as
Yes.
displayed or, talked about concepts, and you can't protect those if they're verbal. You may be able to protect copyright in them if they're expressed in some tangible form. But having that non-disclosure agreement in place, it just sets the tone that says we are bringing a lot of valuable insight to the table, and we know we have to do that. That's table stakes for getting you to consider us to do business with you. But until we agree otherwise, these are our ideas. We're sharing them with you as examples of how we can, serve your business and get it farther. And they're not for taking until we agree on terms.
Yeah, I really like that too. And I think it's that shift in perspective too, between the non-disclosure feeling like a barrier or this agency is really difficult to work with. I think when you present it as, we're going to commit our time and our thought and our strategic ideas, and we're going to bring together our team, we're about to work really hard for you. I think that's a different way of looking at it than we're making it difficult for you to work with us. We're about to pour a lot of our experience and strategy and ideas into putting something together for you. And this piece of paper proves that. So we're going to need you to sign off on that. So I think even coming at it through that way will hopefully get agency owners to start thinking about that a little bit differently.
I always say that for agencies, after your people, your intellectual property is your most significant asset. And I think agencies devalue it or undervalue it because they're so used to creating it every day. It's just kind of what they live and breathe. It's your inventory. It is your inventory. If you, ran a popcorn shop, would you give all your popcorn away every day in the hopes of somebody promising to buy more popcorn? Probably not. Or you'd put a limit on it. And so what we're saying is, think of your ideation, your creativity, and your insights as they may be table stakes for having the conversation, but they're your inventory. And so you need to be thoughtful about the circumstances under which you share them.
Yeah, I think that's really great advice. Okay, so we've talked about a variety of things. Are there other blind spots you see agency owners have? So it sounds like intellectual property is a big one. I think another one that I've also seen myself, as we talked about some of that scope creep, starting work too early. What other blind spots do you see agency owners often have when it comes to legal?
I think we consistently see agencies being a little under formal, if you will, in how they deal with their freelance and contractor benches. We see too many verbal, email, and other informal styles of arrangements or engagement of agencies with freelancers or contractors they want to bring in on a temporary, for a season or a reason or whatever it might be. Or also agency to agency collaborations where you are bringing in another agency for some specific part of a project or to team with you to maybe get a piece of business. Agencies are just routinely underdocumented in these situations. And it's a challenge. I mean, they're the typical IRS, rules that we all have to keep in mind. And many states also have become increasingly restrictive about rules around independent contractors and how they're classified and how you avoid inadvertently having them classified as employees, which is what everybody's trying to avoid. But beyond that, the number one thing I want agencies to understand is if you engage a contractor, somebody who's not a W-2 employee of yours, or if you're working with a strategic partner or a vendor, you don't own the rights to any of the work that they do. And neither does your client, even if those people are paid, unless you've got an agreement in writing that says that you do. And that's not a problem until it is. And it becomes a problem a lot more frequently than you might think. The rights have to waterfall between the contractors to the agency to your client, who's expecting at the end of the day, in most cases, to own all the work that is paid you to create. So the document is important for many other reasons, but documenting those contractor relationships is just another big oops that we see agencies routinely. And again, it's because they're moving fast. Agencies love to move fast. They don't like anything that slows them down. And we're all friends here. So, why create drama where there doesn't need to be? Which, if you've got a toolkit at the ready of all this stuff, it doesn't have to be dramatic or slow or any of those things difficult. It just is, you just activate your process.
Yes. So can you give us a specific example of that? Because I do think that's an important where you're talking about, this waterfall effect of your client doesn't own it. Who owns what? Can you give us an example of where you've seen this happen or a made up one?
I've seen lots of examples. I'll just give you a couple. One example we saw was a freelance artist who created identity systems for a client who did that work. They were engaged by an agency to do it because it was the agency's contract to do that work for the brand. And there was inadequate documentation of the relationship with the freelancer. So not only does the client not own their own, logo or brand system elements because the freelancer never had a written agreement with the agency who produced this stuff and gave it to the client, but you see the freelancer splashing this stuff out on their portfolio websites with the link to the client's website, as if it was their client directly. So it's a bunch of problems. It's cutting the agency out of the relationship. And it's also not cementing the client's rights in work that they think they own. So that's probably the best problem example I can think of.
I think that's a great one. Yeah.
Yeah.
Yeah. And I think we can see how, hopefully agency owners are seeing too, how that may impact their own agency. And so what do you recommend there? What would be a gold standard, if you will, for bringing in independent contractors or freelancers?
The gold standard and the easiest way to shortcut any delays with this is to have a standard independent contractor agreement that, sets intellectual property rights in favor of the agency in whatever work that the freelancer is creating for them on payment. Of course, you want to be fair, obviously. But it also has appropriate unfair competition language. You don't, as an agency, want a freelancer competing directly with you for your client's business. That's unfair to the agency who's brought the opportunity to the freelancer. So you need to address all of those things. Increasingly, the other thing you need to be thinking about addressing is use of AI. If your contractor or freelancer is going to use AI to create any of the deliverables that it's producing for you, you need to know it. It's not bad or wrong. It's something you need to know, though, so that you can disclose that to your client, which may or may not have anti-AI use policies or may create implications for ownership of the final, deliverable. So those are some of the high points to address, and the way you address it is you have a well thought out standard intellectual property agreement. Sorry, independent contractor agreement.
Perfect. Okay, that was so great. And I thank you for sharing that. I was wondering if we were going to get like the team component of this. We were focused a lot on clients. So I'm
Yeah.
glad you brought that up. So as we're wrapping up here, I guess as a final thought or question, are there any maybe common mistakes you see? The situation where the agency owner maybe thought that they were doing things, legally, and they were all buttoned up, and you were like, you kind of missed the mark. Is there anything in particular that sticks out for you there?
I think we've talked about two of the main sort of business focused missteps that we can see agencies make. I would say the other area of concern would be making sure your team members are adequately educated in the legal issues that relate to creating the work itself.
Mm,
So things like understanding trademark due diligence if you're a branding agency, things like understanding rules around copyright if you're using, stock imagery or stock fonts or AI to create any of the assets. What the fair advertising rules require if you're creating a campaign that has product claims. What the FTC requires in an influencer campaign. So if you're the ones who are the ringmasters for making all of this happen for your brand client as an agency, your team members, they're not supposed to be lawyers. You don't expect them to, be legally advising folks, but they need a working knowledge of when there's an issue that should make them stop and ask a question and get somebody to make a judgment call about the legal issues that affect the work and the campaign itself before that work gets out into the world. So I would say that's the third area of risk. And also, the easiest way to adversely affect the fortunes of the agency is to lose a client because you've caused them some sort of legal,
yeah.
drama because nobody spotted an issue.
Yeah. Yeah. I think you kind of, said that before, like it's not an issue until it's an issue, right? Like you can go and it not be a big deal, but when it's a big deal, it's a big
It
deal.
can be, and,
Right.
the goal is for it not to be, and, it's a lot more expensive to have to get a new client than to keep an existing client happy, and
That all the
so,
time.
yeah, an example of how legal, affects your profitability as well.
Exactly. Okay. And then I saw one thing pop up here. Sam was asking, can you repeat the 3 Ds? They got two down in their notes, but not the third.
Sure, dollars, deadlines, deliverables.
Perfect. All right. Thank you so much. You just shared so much incredibly valuable information, so much
Sure,
knowledge with us.
yeah.
Do you want to tell people? I know you have a podcast where, if people are listening to this thinking they need to learn more and dig a little deeper into their own, agency legal needs, where can they find more help and information?
Thanks, Melissa, first of all, for having me today. This was a fun conversation. So, a couple ways you can reach me. I do host the Innovative Agency podcast, which is not a legal podcast, but is about issues of innovation in the agency world. So check that out. The firm, it can be found at legalandcreative.com. My email is Sharon at legalandcreative.com, or you could use info at. And I'm very active on LinkedIn. So I'd love to connect with any of you there. And if you've got questions, feel free to reach out to me there as well.
Great. Thank you so much. Be sure to
Yeah.
find both of us on LinkedIn. Thank you, Sharon.
Thanks, Melissa.